So J. Pavarotti put out another new video, this time claiming that Kohberger has a co-defendant because once again he's misinterpreting the legal documents. Now, I could understand why he might think that it means something it doesn't, but considering his track record, he should honestly talk to somebody first before he runs with some of these things so that they can kind of point him in the right direction. But I just wanted to show you using not only the disclosure motion from the Kohberger case, but one from another Idaho case, just to show you how two different attorneys approach the same thing.
There is absolutely a co-defendant in the Brian Kohberger case. And you'll all find that out at trial, but we're going to go ahead and we're going to dive in right now so that we are not caught off guard during the trial when this gets brought up.
Okay, first of all, if there was a co-defendant, this would not be a surprise at trial. A co-defendant would already be charged. They would already be facing trial, either conjoined with Brian Kohberger or separated. So if you remember Chad Daybell and Lori Vallow, they initially were going to be tried together, a conjoined trial. And then their attorneys argued for separation. And I can't imagine if there were a co-defendant, if Ann Taylor would let it go forward as a conjoined trial. She would want it separated so that Brian would have more leeway with evidence and everything else. But they don't spring co-defendants on you. It just doesn't suddenly become, surprise, there's a co-defendant. This is not like an informant. It's not a secret protected person. A co-defendant would be known. Their name would be out there. They would have been arraigned. They would be facing trial at the same time as Kohberger, again, unless there was a motion to separate. So there is not a co-defendant.
We can go all the way back to the beginning in the state's response to the defendant's request for discovery. And it's plain as day there for you. And a lot of people looked at that, and it's, even though it's plain as day, they just gloss over it.
Actually, it's not plain as day. So let's take a look at the defense's discovery request. Okay, so here's the defendant's request for discovery, and you'll notice a pattern here. So it starts out with statements of the defendant. Then it goes to statements of a co-defendant, defendant's prior record, yada, yada, yada. You can pause and read all of this all the way down to 18. Now, did you happen to notice that everything listed there was word for word to what's in ICR 16? Yes, all the defense did was copied and pasted ICR 16. So what that is boilerplate. ICR 16 lays out everything that the defense can ask for per discovery law. So they copied and pasted it in there. So the second part about a co-defendant doesn't mean that there was necessarily a co-defendant. That is just standard language of what can be requested. And here was a comment from an attorney that was asked about this back when the defense request first came out. Okay, this was with an interview with Duncan Levin, who's an attorney with Levin and Associates in New York. And he explained that this is just part of standard requests for discovery in a case. He said the move from the defense does not indicate that there are other suspects. The probable cause affidavit makes no mention of a co-defendant, and law enforcement officials previously said they believe he acted alone. And he pointed out that's just one of 18 discovery requests made in that motion. So yeah, it's not that people were glossing over that wording. They were looking at it, but they just understand that it is boilerplate. They copied and pasted ICR 16 into the discovery request, because that's the most efficient way of putting in everything that they need to ask for, even if it applies or doesn't apply. You think of it as a fishing expedition. They're casting the rod, putting their line out there to see what they'll catch. And that doesn't mean that there is something for every single one of those requests.
Number 2, any written or recorded statements of a co-defendant and the substance of any relevant oral statements made by a co-defendant, whether before or after arrest, or I should say before or after we killed him, in response to interrogation by any person known by the co-defendant to be a peace officer or the agent of the prosecuting attorney, have been or will be disclosed or otherwise made available. Once again, if this was just a standard response, then you would not see Exhibit A. They've provided the evidence for the co-defendant statements. There's a co-defendant in the case, folks.
Okay, Jay is under the mistaken impression that when the prosecution replies with see Exhibit A, that means there's actually something in Exhibit A that addresses that. That is not the case. There may be, there may not be. Also, he seems to think that Kopaka is the co-defendant, because you notice he made that little comment about him being dead. A co-defendant can't be dead. So if it were Kopaka, there would be no co-defendant at all to talk about, which there still isn't a co-defendant. None of these documents prove that there's a co-defendant, but it definitely would not be somebody that's dead, because it would have to be somebody that's been arrested and is awaiting trial along with the other defendant. That's a co-defendant. But let's take a look at the state's response. Okay, so we'll just start here with the state's first page, and it's really just basic. You can pause and read it if you need to, but it starts out with 1, the any relevant written or recorded statements. And you'll see that they respond to that with see Exhibit A. And then 2, any written or recorded statements of a co-defendant. But you notice I also highlighted have been or will be disclosed or otherwise made available. So it's basically telling you that if there was a co-defendant, it would have been disclosed, or it may be disclosed at a later date or otherwise made available. See Exhibit A. But this doesn't mean that there is anything in Exhibit A about a co-defendant. It just means they're responding to all of the requests by saying, see Exhibit A. Defendant's prior criminal record, if any. Now, Jay Embry did go on to say that that was being disclosed because of Kohberger stealing his sister's phone. But that record was sealed. That's a juvenile record, and he was never convicted. So that wouldn't be turned over anyways. That would not be considered a criminal record that could be turned over. But it still says see Exhibit A. That's because they're just responding automatically, see Exhibit A. Any books, papers, documents, photographs, etc. They put see Exhibit A. Now, Embry pointed out there's the section down below see Exhibit A, and he says you notice they didn't reply to that one, so that means there's nothing in Exhibit A about that. No, that's not really what it means. It's all included on that see Exhibit A part. And then 5, any results, reports of physical or mental exams. They responded, see Exhibit A. 6, written list of names, addresses, all persons, see Exhibit A. Now, Embry brought up again about the state generally does not seek NCIC reports or Spillman reports, so that's why they didn't put see Exhibit A. But it's actually all rolled up into that see Exhibit A. 7, any written summary report of any testimony that the state intends to introduce pursuant to Rule 702, 703, 705, see Exhibit A. Says it does not necessarily include disclosure of expert witnesses, opinions, etc. It's still all rolled up into see Exhibit A. 8, any reports or memoranda in possession of the prosecuting attorney, which were made by any police officer or investigator in connection with this investigation, see Exhibit A. 9, all material information within the prosecuting attorney's possession or control, which tends to negate the guilt, blah, 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 so that's exculpatory. See Exhibit A. I'm going to get to this Brady part later because Jay Embry kind of misunderstands Brady. Now it says, to the extent that information exists regarding an informant who is not going to be produced as a witness, including recording statements. Notice it does not say see Exhibit A there. That's because there's certain things that do not have to be turned over in discovery. So therefore, they're not even going to bother with see Exhibit A because it's just known that they don't have to provide anything at all. That's the same with 11. The state objects to requests by the defendant for anything not otherwise addressed above on the grounds that such requests are outside the scope of ICR 16. And then 12, whenever this response indicates that certain evidence or materials have been or will be disclosed or otherwise made available, blah, blah, blah. You can pause and read this. And that one is also, would be part of Exhibit A if it ends up being needed for inspection, basically. And then it says, pursuant to ICR, the state subsequently discovers additional evidence or evidence of additional witnesses or decides to use additional evidence of witnesses, the state will promptly notify the defendant and the court. That's why we say discovery is an ongoing process, because as new things come in, they will decide if it needs to be turned over or not based on ICR 16. And here is Exhibit A. It's police reports and documents covered by ICR 16, which are in the possession of the state and have been disclosed to counsel for the defendant as of January 23rd, 2023. They consist of pages numbered 1 through 995, audio video AV000001, and photos, which are also numbered 1 through 1865. And this is on a Bates numbering system, so you might see Bates brought up during trial. But Exhibit A may or may not contain any of those things requested by the defense, which would include a possible statement by a co-defendant. So basically, they just responded, see Exhibit A, 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 except for the couple places where there was no requirement for anything to be turned over. Whether they had something or not, those things did not meet the requirement. That would have been the IGG at the time, because the judge hadn't ruled yet that some of it had to be turned over, and it was exempt from disclosure prior to that. So those couple areas where they didn't put see Exhibit A were because they absolutely did not have to respond at all. But on everything else, they chose to say see Exhibit A. That does not mean there's anything in Exhibit A pertaining to that discovery request. That's just a blanket see Exhibit A. Now we're going to take a look at a response from another case in Idaho where there also is not a co-defendant, and we'll see how that prosecution responded. Okay, so this is the state's response to the defendant's discovery request in the Jeremy Albert Best case. And he is accused of murder, and there is not a co-defendant. And this is just a statement about the state has made available for inspection, provided or is in the process of providing the following to the defense. So it's talking about any exculpatory or impeachment evidence under ICR 16. So they separated that out because that is just a given. Idaho law says that any exculpatory has to be given. So they put that right up front. Then the next page starts going through everything that we saw in the Kohberger request, because this again is basically a copy and paste of ICR 16. So statements of the defendant, statements of any co-defendants, defendant's prior record, documents, and other tangible items. And it's saying copies, like right here under co-defendant, we know this person does not have a co-defendant, but it says copies of any relevant written or recorded statement of any co-defendants and a summary of any relevant non-recorded oral statements of any co-defendants in response to interrogation by any peace officer or agent of the TCPA. That is just boilerplate. And it keeps going. Again, same things that was in the Kohberger one. Reports and examination of tests, state witnesses, expert witnesses, police reports, digital media. Now, how they handled it was instead of attaching an exhibit with discovery, so photos, video, files, they are basically saying that you can go find it at 230 North Main Street in Driggs, Idaho. So it says the materials described herein are identified by the Bates identifier state 00001 through 02977. Unless otherwise indicated, these materials are stored via hard drive and available for inspection at the LEC at 230 North Main Street in Driggs, Idaho, upon coordination with TCPA and selection of a mutually convenient time. This is a matter of courtesy, and the electronic discovery on the hard drives are available for inspection and shall be the official source of discovery in this case should any discrepancy arrive as to whether any specific item was produced. Certain materials produced by the state contain protected information as defined under Idaho Criminal Rules 16D 1A and C, including personal identifying information of witnesses. So this, of course, is where they're talking about things that don't have to be turned over and informants. But you notice they just did a blanket reply also. Basically, their reply was the same as C Exhibit A. It's like, these things, you can come look at it. Now, does that mean that there's a reply to every single discovery item? No, it doesn't. But these are all the things that by law, they would have to turn over if they have. So if they have it, it's going to be included in that file. But there's nothing saying that they do have it. So when it says there's a co-defendant, when it talks about a co-defendant, we know that Jeremy Albert Best does not have a co-defendant. So there's not going to be anything in that file about a co-defendant, but they still have to put this blanket reply on here. So it's the same thing as the C Exhibit A on all the sections of that Kohberger response. So in both cases, Kohberger and Best, we know they don't have co-defendants. But this is all canned wording. It's boilerplate. And then when the state responds, they're just like, bump, here's where you can find all the discovery. And it doesn't mean that there's something in that discovery that pertains to that particular request. There's probably a lot of things requested that there was nothing pertaining to. So it's not going to get turned over because it doesn't apply. But they're still going to put C Exhibit A. Or they're going to say, oh, this is all available on a hard drive at our office. Like, I like how Teton County did it there. That was pretty cool. You can go see it on the hard drive. So I don't know if somebody that personally knows Embry can maybe try to make him understand this. That just because there's boilerplate language on a document and that the prosecution replies with a blanket, see the exhibit, because it's something that is discoverable if they have information about it. It doesn't mean that there is a co-defendant. So if somebody could just let him know, because me and others have tried to tell him in the comments, he doesn't listen. He's completely misinterpreting every legal document he looks at, and it's kind of frustrating. Now, one other thing that he misinterpreted, I'll show you.
We got the Brady stuff here, ICR 16A and the Brady, so they're not disclosing that because they're seeking protection under Brady.
Okay, let's take a look at the Brady Rule. The Brady Rule is named after Brady v. Maryland, which requires prosecutors to disclose material exculpatory information in the government's possession to the defense. Brady material, or the evidence the prosecutor is required to disclose under this rule, includes any information favorable to the accused which may reduce a defendant's potential sentence, go against the credibility of an unfavorable witness, or otherwise allow a jury to infer against the defendant's guilt. Okay, so there's no protection under the Brady Rule. Jay is completely wrong. Brady is about handing over exculpatory evidence, which also can include something that can impeach a witness's credibility. So, like, this is where it would come into play if somebody from law enforcement had done something in the past that was shady on another case, or they have something in their training record that they've been reprimanded for. That has to be turned over, because that could be something that could be favorable to the defendant. So it's another rule about exculpatory evidence. And that also kind of goes hand in hand with Giglio, which is where they have to disclose, like, if any deals were made with somebody, like with an informant, things like that. So it's anything that is favorable to the defendant. So there is no protections there. So him trying to say that the C Exhibit A not being there is because they're getting protection to not turn something over is just completely wrong. So I hope that helps. Any of the documents that I've referenced are available on the Idaho Judicial Cases of Interest site, and also the Idaho codes are available on the Idaho state website, either on their legislature page, or you can actually just Google ICR Idaho codes. Now, I've had a few people sending me suggestions for what they would like me to cover, so if there's something you would like me to do a video on next, let me know and I'll look into it.